Hi, this is Rahul Reddy. Along with me is REDDY NEUMANN. We're live here from Houston, Texas. Like every Tuesday at 5 p.m. Central Time, we do come. We're immigration lawyers from REDDY NEUMANN PC. We're both partners in REDDY NEUMANN PC. We're in business from past 21 years. We are here to present our immigration things. Emily?
Yeah, so every week we update you on the latest that's going on with immigration, specifically geared towards employment-based immigration in the U.S., and we take your questions live. So today, some of the topics we'll be covering are F1 students and the Unlawful Presence Memo, as well as the litigation that's going on about that memo and what that means for you. We'll be talking about the visa bulletin that just came out and downgrading from EB2 to EB3, specifically for those born in India. Canadian immigration. Of course, we're not Canadian immigration attorneys, so we can't talk about that, but if you choose to become a Canadian citizen, what impact would that have on your U.S. immigration options? And of course, taking all of your live questions, updates on the H-4 EAD, H-1B lottery, coming up in April. Lots going on as usual. So I guess one of the first things to discuss is the proposed regulation that would change the H-1B lottery system. So this is for cap subject H-1Bs that are normally on the first 5 business days of April. We had a proposed regulation that would change that to an electronic filing system where you would first submit your registrations, and then the government would select from those online registrations to decide who actually is going to get the visa, and then you file your petitions. So we had that proposed, and the comment period ended on January 2nd. Normally, we would expect it to take a couple of months for Department of Homeland Security to review all of those comments before they go forward with a final rule. But this time around, in 2 weeks, 2 weeks after the commenting period ended, they've already proceeded with a final rule and submitted to the OMB, Office of Management and Budget, for their final review. So it looks like they're going to be moving ahead with this electronic registration system. So, do we have any news about what it is and how it's going to work out and when we'll find out?
We will have to take a guess right now. At this time, we are assuming that the proposed regulations, what they have done, will most probably will be finalized because they haven't released any information at this point of time. The employer is supposed to submit the information of the employees whom they want to file a H-1B. And once they do that, a lottery system will be conducted. And once the lottery system will be conducted and the employee is selected, the employer is supposed to file the application. Emily, do we have any guidelines? What information in the proposed regulations? Of course, we don't have the final regulations. What guidelines we need to have when the employer submits those things?
Yeah, it was really very basic what they're looking for. So we think that the employer will have some sort of account that they can log into, and then they would submit the beneficiary name, passport number. That's possibly about it.
Yeah.
You select whether they're filing in the master's cap or the bachelor's cap, but no information has to be submitted about the job offer, the LCA, the wages, nothing, just very basic.
But anyway, if things go successfully, it should avoid a lot of confusion among whether or not your application has been selected in the lottery, the cap, people should have a clear guidelines with regards to whether they or not. But as a warning, we request all the people that if you are about to file an application in this new quota, we would want you to prepare an application as if that there is no new system that exists. If and when the new system exists and then it comes in, it's easy to adapt to the new system. But what we noticed is that there are other systems with the USCIS has been interpreting those things, especially for the H-2B visas, not H-1B, but H-2B. It went broke, it was a big mess. So I want all of you guys to be prepared with a manual, regular application to be ready. And if the new system comes in, you can plug into the new system. You still need to file the old way. It's not You're not avoiding filing the old the application. It's just that you unnecessarily don't have to file if you're selected in the lottery or not. You don't have to wait. But please be prepared with the application and get it ready. And if the new system comes in, you plug into that new system.
All right, I want to move on to the August 9th Unlawful Presence Memo for F1 students. We've been talking about this pretty much since August 9th every week. And there's a lawsuit that was filed about this memo, and I'm getting a lot of questions on my blog, immigrationgirl.com, saying, well, what is this lawsuit going to do? Will it stop the memo from taking effect? Will it, save people who might be subject to a 3-year bar February 5th? And so yes, there is a lawsuit that was filed by a group of colleges back in October. They're basically arguing that this new policy memo is unlawful. They have several reasons why they're arguing that. Number one, it didn't go through any kind of regulatory process. Like we just talked about this
H-1B
regulation, that is going through the regulatory process, although it's a very fast one, but they submit what is their proposed change, let people make their comments, and then they have to issue a final regulation that explains what they did with those comments and why they chose how to proceed. Now, in the August 9th memo, there was a comment period, but it was not like a regulatory comment period. It was very brief. They didn't have to put forth any explanation of why they chose to do what they did when they came out with the final version on August 9th. The only change they made was the section regarding reinstatement. And so because it didn't go through that regulatory process, it might be considered a violation of the Administrative Procedures Act. They're also arguing that the change in the policy is completely arbitrary and not based on any real sound reasoning. They claim it's based on this overstay data that they had, but really the data is very misleading the way they were putting it together. And they just say it violates due process when you are told you're violating your status, and oh, by the way, we're going to impose the penalty from 9 months ago when you started violating your status unknowingly. That's really unfair. So that is why this lawsuit was filed. Now that, again, it was filed back in October, so now we're in January. The lawsuit is still at the very early stages. So the first thing that the colleges did was file a request for a preliminary injunction. Basically, they're requesting the court to suspend this memo while the litigation is going on until a final decision is made in the litigation. Now, of course, DHS has submitted their brief in opposition to that. At the same time, DHS has filed a motion to dismiss the lawsuit completely. They claim that the colleges lack what's called standing to bring the lawsuit, meaning they're not the ones that are being harmed by this memo, so why should they be the ones to bring a lawsuit? And it's too soon to bring a lawsuit because no one has actually had this memo applied to them yet. So that's kind of what DHS is arguing. Now, both sides have to submit briefs in response to each of these competing motions towards the end of January. But I'll tell you, don't expect a fast decision on any of this. Those of you that have been around a while and remember the STEM OPT litigation that created our new 24-month STEM extension, that lawsuit went on for 18 months before we got that decision.
Yeah.
So we're just at the very early stages. So if you're in a situation where February 5th is an important date for you because you might be triggering the the 3-year bar for 180 days of unlawful presence, don't rely on what's going on with this litigation to solve that for you.
Emily, why the August 9th memo doesn't say anything about the the 3-year bar or 10-year bar? Why is your law firm saying that the memo implies the 3-year bar and 10-year bar for those people who are violating the student visa status?
Yeah, I mean, it's complicated. It's all legal issues that all combine to create this result. So the memo is one part that now says that status violation equals unlawful presence. That memo was not issued in a vacuum. It was issued with all the other immigration laws surrounding it that are still good law. The main one is unlawful presence. The bars that triggers.
That's a core for which they pass that memo.
Right. So that unlawful presence concept was created in 1996, 1997. That's when the 3 and 10-year bar were created. And the whole purpose of this memo is honestly to catch students unknowingly and get them out of the country. And that is one of the arguments that's made by these colleges in this lawsuit as to why it's so harmful, because it's clearly the intention of DHS to trap students into unlawful presence without even knowing.
I want to ask a couple of questions on the student visa assembly, since we're on that topic, and I'm getting a lot of questions from the YouTube. If the person, if the person is about to get to the STEM OPT extension, which is only given for the e-verification employees, now there is a shutdown of the government on the e-verification. Can they work while the whole process is going on? I mean, while the...
Yeah, so the STEM extension does require your employer to be an e-verify company. Now, if you are joining a new employer as part of your STEM extension, normally that new employer would have you fill out the I-9 paperwork to show that you're lawfully, legally allowed to work in the country. And then the next step for e-verify employers is to take that I-9 information and enter it into the e-verify system to get a confirmation that you are in fact authorized to work. That second step of the e-verify cannot be done right now because of the shutdown. That doesn't mean that you can't start working. The STEM OPT requires that your employer be enrolled in using e-verify, but they're prohibited from actually entering you personally right now due to the shutdown. That's okay. You're still authorized to work. You can still work for them. Once the shutdown is over, they will then enter you in e-verify at that time.
That's good. So even if they've shut down, it's not interrupting. One thing is that there are a lot of issues on the day one CPTs. We've been advising people. There are also issues with regards to complying with the regulations of the STEM OPT. Now that is given for those people who have a STEM degrees. After they completed the initial 12 months, they're out of work for the rest of the next 24 months. But of course, you know, there are regulations. How, with all these things, the students coming on the F1 visa, staying, going to the college, then OPT, then STEM extension, then H-1B, can you run through what is a better process for these students coming into this country genuinely for education purposes, what they should look for, and how they should comply with the regulations? Because remember, all these people are coming from definitely not US citizens. They're not green card holders. They're coming from outside. They come from different background and different socio-economical and legal things that they have back in their country.
Yeah, they might not be familiar with all the different colleges and universities in the United States. And so you really have to, as an incoming student or thinking about coming into the US on a student visa, you've got to choose the right school. Not all schools are created equal. Not all of them are following the regulations properly. So you have to be really careful of that. So number one, the school has to be an SEVP certified school, meaning that DHS has approved it to issue I-20s. So that's the basic thing. The next level is looking at, is this school accredited? Now, just because DHS has allowed them to issue I-20s doesn't mean they're an accredited school. You have to make sure they're accredited so that you can actually use the degree that you're coming here for. When employers are looking to hire you and sponsor you for later work visas, it needs to be an accredited program. Now, going from there, there are some schools that I would say seem to, I guess, target international students and maybe sound a little too good to be true. These day one CPT schools are top of the list of that for me. You know, if you're going to that school and, you know, there's not really any kind of admissions requirements, they'll take you in any time of year, regardless of whether the semester has already started or not. If you look around and it's only international students there, or maybe you don't even have to go on campus. There is no campus. We don't even know. Some of these schools are just conducting classes once a month, or even less than that. And you know, you have to really think about, is this proper? You know, thinking back to the University of Northern New Jersey, it was a fake school created by ICE to trap students. I'm not saying these are also fake schools that were created by ICE, but what brought those students to that particular school was how easy it was to get in. There was really no admissions process or requirements. They could bring them in any time. They were authorizing OPT, CPT. You could work as much as you wanted, which is definitely not in line with the purpose of the F-1 visa. So I think those are some of the things you should look out for. If you go to the school's website and the first thing that you see that pops up, it says Day 1 CPT, or we help with, if it seems like they're targeting international students more than just having a regular website that talks about the school and their admissions process, those are some of the schools to keep an eye out for.
Yeah, one thing is that if they are not conducting the classes, they are not requiring that you attend the classes, and they are giving the employment authorization just like that, just because you joined them, and they have no criteria for their admission. I mean, you present in this country itself is a criteria for them. That's it. You can join doctorate, any degree. That's a good indication for you to learn that that doesn't sound good, because that's not how a university should operate. I mean, they should have classes, they should have the things going on smoothly. Now, we did notice that out of the 3,000 SVP institutes which Emily is pointing out, we have to admit that the only 10, up to 10 universities are those universities that might not fall into a good category according to our definition, because they are issuing the Day 1 CPTs, they are not requiring students to go to classes. I mean, they're just telling people to attend classes once in a month or once in a semester. That's definitely a big criteria. We have had some issues with other universities called Tri-Valley University before, and there were some issues with regards to Silicon Valley University, if you recall. You can Google those names and find out what happened to those universities. So you will be able to get an idea of the universities that are granting you the Day 1 CPT. Most probably they'll end up there. Emily, there are a lot of questions coming on, and the main question that's coming on again and again is Trump tweet. He wants to make H-1B simple. He wants to make the path for the citizenship. Well, what do you mean by citizenship is green card. Typically, the politicians use the citizenship word instead of green card. He wants to make the path for the green card easier for the H-1B. How genuine he is, and what are the hurdles if he even wants to do?
Yeah, I think that tweet definitely came out of the blue. I mean, if you've been following what the administration has been doing for H-1Bs for the last year and a half, it sounds exactly opposite of what they've been intending. Ever since Buy American, Hire American, H-1Bs have been more difficult to be approved. We have issues with getting level 1 wages approved. We have specialty occupation denials for people who've been in a specialty occupation for 3 or 6 years already. Now all of a sudden it doesn't qualify. Beneficiary qualifications are no longer good enough. We have the computer programmer memo. We have the RFE memo. We have the NTA memo.
NTA memo.
So all of the actions taken by the administration are completely opposite this one tweet. So I would definitely not be getting my hopes up. I think that the timing of the tweet coincides with when the final rule for the lottery was issued to OMB. That happened on Friday. So that's probably what he is referring to. Is you trying to make the lottery process smoother and easier, which to an extent it will.
Yeah, it definitely.
It definitely will, but it's got its problems. I'm really concerned if they didn't do anything to deal with the fraudulent filings, that the number of people submitting registrations in this lottery is going to be way bigger than we've ever seen before, which reduces everyone's chances of getting selected. As far as that path to citizenship, if we're talking about the changing how H-1B holders can go from H-1B to green card to citizenship, pretty much everything in that realm has to be done by Congress. I mean, if there was a change that the president could make, honestly, it would be to not count dependents towards the green card cap, the quotas. We've talked before about how that's technically not how the statute is written. There's an EB-5 lawsuit going on right now where a group of EB-5 investors is claiming USCIS has been counting dependents wrongly this whole time, and that is something
hold on.
that could...
Can you specify dependents counting where the Trump administration doesn't need to go to Congress, is that there are 140,000 green cards available every year to give for the employment-based immigration. What Emily is pointing out is that when they count the H-1Bs, it's 65,000 H-1Bs plus 20,000 master's degree, it's 85,000. They don't count the dependents into it. However, when the green card application is coming, they're counting the dependents. So if the Trump administration wants, they can issue a regulation and probably not count the family members, in which case instead of 140,000, it's going to be 300,000. He can do it if he wants to, and that might eliminate or practically reduce the amount of waiting time from 10 years to probably less than 1 year or 2 years. But is there a possibility this administration wants to do it?
Based on every action so far would not suggest that's what he planned, and it was probably just a poor choice of words thrown out there, and we're all hanging our hopes on one tweet in the face of everything that's been going on.
If you look
so
into
far.
the totality of the circumstances of the Trump administration, they don't seem to have an intention to make it easier, make it fairer for the employment-based green cards. If you look into the totality, that one tweet is not by itself. I hope he changed his mind after learning the economics, but if I wouldn't take that as the whole of what the Trump administration at this point of time. I'm getting a lot of questions on YouTube. They're naming the universities and they're rising. I'm about to get expired in February of 2000. My STEM extension is expiring in February. I did not get selected in the lottery. Is it a good idea to join a college to get a day one CPT? Is the first question. Second question is that my university, I don't want to name that, is giving day one CPT. They're very popular in day one CPT. What is your opinion on that university?
Yeah, I don't even know the name of the university mentioned in the comment, but I can say if they're very popular in giving day one CPT and everybody knows about them, I would say they're also highly scrutinized by USCIS at the time of filing your H-1B, and they're certainly on the radar of ICE as well. So no, I don't think that those CPTs are properly authorized. Number one, they're being authorized against what the current USCIS interpretation is, that says that you cannot get more CPT time at the same degree level after you've already used up all of your OPT time. And on top of that, this idea of day one CPT is, that's not what the regulations say. The regulations say when you're in a graduate program, you need to study for 1 year before you can be authorized for CPT. Yes, there's an exception to that if the program requires immediate participation. I think USCIS is really questioning whether all these programs truly require immediate participation. Are there also US citizens at that school who are working through that same program? If they're not, and it's really just a way for F1 students to continue to work, then I think that at some point it's going to come back and bite you, especially with this unlawful presence memo, the 3 and 10 year bar. It's just not worth it.
Subramaniam has this question. What do you suggest, day one CPT or go home?
Go home, honestly.
Yeah.
I hate to say that.
Yeah, one of the thing is that these day one CPTs are going to be a major issue. If you don't go home, you continue it, your chance to being in this country for a long period of time is going to be destroyed. So you need to be careful, because if you do it, your life future will be destroyed. That's the way, because I'm an immigrant. I know I want to come into the United States. I want to work hard. I want to progress. Obviously, I don't have an option right now to work, and it's very tough to maintain. Either I have an option to go back or take the day one CPT. if I know what I know, I would leave the country rather than going the day one CPT. Here is the reason, because it's going to have a long-term impact on you. You will be hit with a 3-year bar and or 10-year bars once you cross August 9th. So I would go home.
And just because you go home doesn't mean you can't be sponsored for an H-1B. You can have an employer file on your behalf while you're outside the country. There's absolutely no problem with that. It might be more difficult to find the job and have the employer willing, but if you've got the skills that that employer needs, they will sponsor you.
I mean, you can also have L1 options, a lot of different options once you go and work in your home country. You may pick and choose. Normally people with a master's degree from a good reputable university here do have a good value in their home countries and getting their jobs in the proper companies.
All right, a question that came up on Facebook is regarding the online I-94. It's not pulling up in the system. Could be a few reasons for that. Number one, it could be because it's too old. This system has been around just for the last 5 years. So if you entered prior to the online system being put into place, you won't find it there. You'll have the paper I-94 that was issued you at the port of entry, and that's still your I-94 if you have not traveled or changed your status since then. If you entered more recently, check your passport number. Maybe you had an old passport and you need to use that number to look it up. If you lost your I-94 that you were given, the paper one, you won't be able to replace it by going to that online system. You may have to file an I-102 application to replace an I-94. A question on H-1B amendment pending, or H-4 EAD application pending, and now the H-1B holder needs to file an amendment. Is that going to impact the H-4 and the H-4 EAD? Generally, no, unless the H-4 and H-4 EAD were filed based on the amendment and then the amendment gets denied, or maybe the amendment gets a shorter validity period, the H-4 and EAD could be cut short. But if they're not filed together and you're later filing an amendment, it should not impact the validity of the pending H-4 and EAD.
Question from YouTube is, can I still be qualified for the master's quota if I am in India and I'm filing from India? If you have a master's degree in United States from an accredited university, you have no problem in being in the master's quota. Just because you're here or you are in any country, it doesn't matter. You will fit into the master's quota.
Yeah, that's a really good question. I think a lot of people are not aware of that. Sharon also has a really good question. Why is consular processing better than filing a change of status for someone who's currently in these day one CPT programs?
We have done a lot of day one CPTs in the consular processing. Here is the reason why we strongly recommend, if ever you still, I mean, it doesn't cure all the things, but it might be a good weapon for you. If you're in day one CPT, do not file change of status, because once the immigration rules that you are out of status, the immigration is telling all the other government authorities and to you that you did not maintain the legal status. Now you're going to a different government agency, which is called the State Department for the consulate. And then you're approaching them saying that, well, one of your government department said that I violated the legal status, but please give me the H-1B stamping. That becomes tough for the State Department when the USCIS are certified that you violated the status. That's the reason why last year a lot of employers have filed the CPT to H-1B cases into consular processing. That's a very good step that they did it. Most of the time, the USCIS did not rule anything on the CPT issue, because when you file in the consular processing, the USCIS does not normally look into your legal status.
Anu has a question about downgrading from EB2 to EB3. What if you file the EB3 I-140 and for some reason it gets denied? How do you think that would impact the EB2 I-140?
EB2 I-140 most probably will still be valid. It won't impact the EB2. However, the 485 application, if it has been filed along with the EB3, will be automatically denied. You can always file a 485 application once the EB2 date becomes current. You may have to maintain the legal status of H-1B until the EB-2 becomes current in case when the I-140 for EB-3 gets denied. It's very, I know a lot of people ask this question, Emily, that is it good to downgrade to EB-2 to EB-3? Now the EB-3 priority date is for filing an application in January is May 1st of 2010, April of 2010, sorry. And for the EB-2, it is in 2009. Yes, I would strongly recommend if you fall into the criteria where you are going to be current in EB-3, I strongly recommend to file an I-140 and adjustment of status immediately. The reason being that these things, the priority date openings to filing the adjustment of status becomes once in a decade sometimes. The priority date become current in 2007. From 2007 to 2012, it was backlogged. In 2012, in the early part of the 2012, it was current until May 1st of 2010. And that was in 2012. And right now we are in 2019. It never moved to May 1st of 2010 in EB-2. So the opening comes very rarely. When the opening comes, it's advisable for you to take a chance and file the adjustment of status. Are there any downfalls? Yes, there might be some downfalls. To go back to EB-2 and file an adjustment of status will become very burdensome unless you maintain the legal status. You may want to discuss with your lawyer, but given a chance, if your priority date is current in EB-3 and you are in EB-2, if I were you, I would file the downgrade into EB-3 application and then file the adjustment of status at the same time. You can do so. You don't have to have the EB-3 I-140 approval. You can file the I-140 and the adjustment of status at the same time. You can do so.
Kellyanne has a common question that we see. He's checking the online case status and all of a sudden it says name was updated. He never contacted USCIS to update his name. The employer, the attorney, nobody contacted USCIS. Why does it say name was updated? Generally, this happens when the USCIS officer has actually taken some kind of action on the case. It could be that during data entry, your name was entered one way, and when the officer is actually reviewing your case, they see it was incorrect, and they go in and fix the error, and then it comes out with his online case status saying name was updated. Sometimes it might not even be the name that was updated. It's just some action likely has been taken by the officer on your case. So nothing to really worry about on that.
Too many questions here. On the RFEs, Emily, how is the trend in the RFE? Any suggestions on the H1 RFEs that you're noticing right now as people are concerned about the denials right now?
I'm not seeing anything new or different than what we've seen for the last year, I would say. It's typically specialty occupation. Can you prove that your job requires a specific degree that's at least a bachelor's degree? You really have to look at the Occupational Outlook Handbook and what it says about your job. There are some entries there that mention too many fields of study that qualify you for the job, and that's one way USCIS says it's not a specialty occupation. And there's another area where the OOH sometimes says that a bachelor's degree is common, but some people can do that job with an associate's degree. If it says that, or that less than a bachelor's degree is suitable for some people or some jobs, USCIS assumes that the job you're applying for is the one that only requires an associate's or a lesser degree. So that's one main issue. If you are working in a third-party site, you need to be prepared to answer employer-employee relationship questions, show how the employer is supervising the employee and maintaining that relationship even though you're placed off-site. Other than that, VIBE is a common request for evidence. That is how USCIS looks up to see that the business is actually existing. So they might ask for tax documents or county or city licenses or invoices or lease agreement, that sort of thing, to make sure the business does exist at the location specified. Every once in a while we see Wage level 1 issues pop up if it is a level 1 wage where they're questioning whether it's a specialty occupation or maybe the job sounds too complex to be level 1. Those are the major RFEs that we're seeing, but I think the big one is the specialty occupation, and that can really be not necessarily avoided, but the argument can be a lot easier if you verify what the Occupational Outlook Handbook says before filing.
A couple of questions from the YouTube. I'm going to club a couple of them together in the H-4 EADs. While the H-4 EAD is pending, can I travel outside the country? Will it have any impact on the EAD? If your EAD, H-4 EAD is pending, only EAD, not the H-4, and you travel outside the country and you come back, it will not have any impact on the EAD. EAD will still be adjudicated. Are we receiving the H-4 and H-4 EAD approvals in the proper timing? They are taking a little bit longer timing, somewhere between 8 months to about 12 months right now. But yes, we are receiving the H-4 and H-4 EADs without any problem. If the H-4 and EAD has been filed along with the H-1B applicant, the H-4 and the EAD are getting adjudicated, approved on the same day, 99% of the time, on when the H-1B is getting adjudicated. Some questions on the premium processing. Is the premium processing going to be back in February 19th, Emily, or what do you think?
That is anybody's guess. Generally, in the past, when USCIS has suspended premium processing and given a time frame where we can expect that it will be back, they've honored that, except this past October when they suspended premium processing back in April and said we expect it to be back October, and then all of a sudden in October they said, oops, never mind, we're only going to allow it for certain petitions filed with Nebraska. So up until that point, I would say usually I believe them when they say it's going to be back at a certain time. I do expect maybe it won't be back across the board right away. They've done that before where they'll start with a certain type of case, and then once they get past that kind of big volume of filings and upgrades that happen right away, then they'll move on and add another type of case that'll be allowed to do premium. I doubt that cap subject cases this year will be allowed to file in premium just based on what they've done the last 2 years now.
Ashok has the very, I don't know, good, bad, I would say, very sad question though. His H-1B that he filed in 2018 April is still pending. Can he file the H-1B in the 2019 right now? And you're telling that we don't know if the premium processing is going to come out or not. Of course, poor guy would have done that. I can tell that he would have done the premium processing, but we have not given the option. Should he file the H-1B under the new quota again in 2019?
It might not be a bad idea. I think it depends if there's been an RFE where you're uncertain whether you'll ultimately get the approval, or if there's anything in the case that might be a little bit riskier, where it maybe won't get approved. Really depends on the specifics and the strength of the case, but it's certainly not a bad idea to file again. I'll tell you, I got a request for evidence yesterday on a petition that was filed last April, and the due date is April 4th for responding to the RFE. Now, of course, even if I respond back now, it might take 60 days or more for them to get the result. So I've got cases in the same situation, unfortunately.
Being an immigrant, Ashok, I would advise you file another H-1B application. You're not doing anything illegal activity, absolutely not. If I were you, I would.
Okay, so don't we always say don't file duplicate petitions? How does this,
well,
is there an issue with that?
No, I don't think so. It's a duplicate application. This application
I
I don't consider this as a duplicate application. A duplicate application is if you're filing in the same quota. It's filed in a different quota. That was 2018 and this is 2019. They have not given an option of premium processing. The same question comes out is that I have two different employers that is coming up, and with two different OP, I'm working at two different employers. Both are genuine employers. Both want to file in the April of 2019. I don't trust these things because I would like this guy to be evaluated by an independent lawyer, not the same lawyers that are doing the H-1B, but an independent lawyer, because a lot of times when we see that both employers, different employers, are filing for the same employee, there's always some hitch to it, 99% of the time. I would want that one to be eliminated to make sure that no fraud is there and there.
So Janya has a question about pending OPT applications. Are they impacted by the government shutdown? No, they're not. Because USCIS is a fee collecting agency, the fee that you paid for your OPT application allows USCIS to process it even during a shutdown.
Mehul has this question. In fact, I spoke with him in the daily conference call. For those people who are listening to this one, we do have a daily conference call. You can go to rnlawgroup.com. We do conduct half an hour daily conference call. And I did chatted with him on last week, and also I chatted with him today, Emily. He went to Ottawa consulate 2 times, in 2012 and later on some other time. In 2012 he got the 221G, but later on he got the visa, and then he went again, he got the visa. He's going 3rd time right now. He's about to go. Now there is an inquiry, since he applied the application in Ottawa consulate, there is an email sent to the end client verifying the employment. What do you suggest him to go for the interview or cancel the appointment?
Well, I mean, assuming the end client responds back favorably with the information that's needed and it matches everything that's in the petition, there's nothing wrong inherently. I mean, usually the consulates are, when there's third-party placement involved, both the consulates and USCIS are emailing the end clients to verify, is this the actual end client letter that you provided? Was someone actually authorized to issue this letter? Is this person actually working for you? Are you aware of them? How are they being supervised? So assuming that the questions are answered by the end client in a way that's consistent with the information that was provided in the petition, there shouldn't be any issues. That email actually helps the consular officer see that everything is accurately mentioned in the petition.
I have my previous I-140 approved, and can I port the date with the new employer? If your I-140 has been approved and not been withdrawn before January 17th of 2017, and it's been approved for more than 180 days, yes, you can port the date to the new employer. Absolutely no problem with it.
Monica has a question about automatic visa revalidation. So she was here on H-1B working for company A, filed a transfer to company B, and now company A's visa stamp that's in her passport has expired, but she has a valid I-94 with company B until 2020. Can she travel to Canada and come back in without going for stamping? And the answer is yes. Under automatic revalidation, an H-1B holder could travel to Canada or Mexico for less than 30 days. As long as you don't go for stamping, you can come back using your expired stamp. They will revalidate it on the day you're entering to act as if it's actually valid that day, just for the purpose to let you back in.
Karthik has this question. How long is it taking for the 485 and 485 EAD applications? Unfortunately, the 485 EAD applications are taking approximately 6 months right now. Now, previously they used to take about 90 days. Right now, they are taking approximately 180 days. I'm speaking about 485 EAD applications. Now, the 485 applications, if the priority date is current for you, it's taking approximately 17 to 20 months right now. That's the time that it's taking, because all 485 applications filed on or after March of 2017, they have to interview them before they give them the green card. That's the new rule. So it is previously 485s used to take, some of them used to take only like 6-7 months if the prior date is current, but right now it's 17 to 18 months, because from the service center it has to go to the district office, and then officer has to personally interview the 485 applicant before they give the green card application for the employment based.
Asif has a question about how to demonstrate that the employer-employee relationship is being complied with, both when you're on the STEM OPT as well as when you're filing for an H-1B when you're working at a third-party site. And there's actually a pretty clear memo on this. It's called the Newfield Memo, came out in 2010. So if you look for Newfield Memo, third-party placement, you'll find it on USCIS website. It goes through a whole long list of factors that USCIS officers will look at to determine whether the bona fide employer-employee relationship exists. In addition to that, specifically for the STEM OPT, you've got to make sure that you're complying with the training plan. Everything that was spelled out in your 983 needs to be actually happening in real life. It can't be just on paper. And you've got to keep up with that, submit those self-evaluations. If something changes in the job, you're at a new location, that has to be updated on the 983. So if you're complying with those things and are following what's in the Newfield Memo, those are ways to demonstrate the employer-employee relationship.
Mukherjee has this question that if can you port the date from EB2 to EB1? Yes, you can port the date from EB2 to EB1. No problem with it.
Shiv has a question, working full-time for a startup company on H-1B, but the company is possibly shutting down. Can he stay in the U.S. until he can find another job? Potentially. It depends on how long the new job prospects are going to take. For H-1B holders, since January 17th, 2017, there's a regulation that created the 60-day grace period. So from the day you stop working, you potentially have up to 60 days to find a new employer and file that transfer, assuming that your I-94 is valid beyond those 60 days. So you can't necessarily stay the entire time if the job search is taking longer than 60 days, but you can potentially stay while you're looking for another job if you can file the transfer within 60 days.
Varanya has this interesting question. Was there any changes in the regulations or rule for the higher education people to get a better opportunity on the H-1B, a better shot? There are two proposals that the Trump administration suggested. One proposal is to overhaul the regulations with regards to the H-1B, how the master's quota is to be selected, and priority to be given to the master's degree. That has not happened. However, the lottery system, how the lottery system has to be conducted, the regulations have been sent to the OMB, they've been proposed. Most probably we are expecting those things to come before this April. If that happens, there is a greater chance for the master's degree people to get into the lottery. Previously, the way it used to do is that the number of people who are applying in the master's quota, they used to conduct the lottery system, and the 20,000 people and some more were being selected for administrative reasons, and then whoever has been not selected used to move into the bachelor's quota, and then the lottery used to be conducted. Now what they are doing is that they are putting all the people, bachelor's and master's people, into one and selecting the bachelor's quota. And those leftover master's people who are not selected in the bachelor's quota are moving into the master's quota. Then the lottery is conducted here. Now, if they do this way, the new way that they are proposing, the master's people have a greater chance of getting than compared to previous year. Assuming if the numbers remain the same, the master's people still will have a greater chance of getting in this new regulations, which is already proposed and we're expecting to go on April 1st.
All right, Pankaj has a question about filing a transfer when an amendment is pending. You can do that, no issues there. What happens to the pending amendment after you filed your transfer? Well, if the company doesn't withdraw it, it'll continue to be processed. So either at some point it will be approved, or you might get a request for evidence, and at that point, if the company no longer wants to reply, they'll probably withdraw it. But there's not an issue with that.
Absolutely no problem with it.
Another question, Mahadev wants to know if an H-1B extension, amendment plus extension is being filed and it's pending beyond the 240 days, can you keep working? Now, there's no guidance from USCIS on this. I have seen some attorneys with some creative legal arguments that could suggest that maybe you could work beyond the 240 days. I've not personally tested that with USCIS, and what's difficult is there's really no way to get an answer from USCIS. I mean, when they're adjudicating your extension, USCIS doesn't know whether you kept working beyond 240 days or not. And so I don't know if we'll ever get guidance that specifically says, yes, you can do that, or no, you can't. It's just kind of a gray area that if it ever comes up, there's a creative argument that could be made, but I don't know if USCIS would buy it.
Is there a difference between 1 year and 2 year EAD and 485? That's a question asked on the YouTube. There is no difference between 1 year and 2 year EAD. It's up to the officer. It's up to the discretion of the officer to give either 1 year or 2 year. We most probably are seeing 2 years EADs, but sometimes officers are issuing only 1 year EAD in the 485. There is no appeal process. There is nothing can be done if that is there. We just have to reapply the EAD application again.
Arun wants to know if you're an H-4 EAD holder and planning to file an H-1B in April and it's selected in the lottery, does the H-4 EAD remain valid? Yes, it does. I mean, if the H-1B is ultimately approved and you've changed your status, you're no longer in H-4 status, so you no longer use that EAD, but the EAD itself doesn't go away just because you filed an H-1B in the lottery.
Sheikh has a very good question. In fact, I'm about to write an article on this one. His STEM extension OPT expired and he is on day 1 CPT. He wants to now travel outside the country and come back. That is, we have noticed that they have denied admission to some of the people who are on day 1 CPT when they are coming back into the country. The CBP found that these people are not attending the classes which they are supposed to do on CPT, and these people are going to colleges that are not conducting any classes other than once in a month or once in a semester. They have been denied entry into coming to the United States. So I would recommend that you contact the lawyer. Day 1 CPT by itself, we don't consider that to be good at all. You may want to leave, but if you are planning to come back, you might be in big danger in coming back into the United States.
I'm getting a lot of questions about processing times for H-1Bs at the California Service Center. Their current processing time is 8.5 to 11.5 months. That goes for quota, new cap cases filed last year, transfers, extensions, amendments. Anything being filed in California right now is taking about 8 to 12 months. And if you haven't crossed that time period, they will not accept a service request either. So there's not a whole lot you can do until premium comes back, or you could potentially request an expedite. But with so many people requesting expedites, it's less likely that that will be allowed.
It's time, Emily. We're having a lot of questions, but for those people whom we could not attend, we do have a daily conference call that you can log in at any time at www.rnlawgroup.com, and you can ask any questions. Every day we do conduct a free conference call for everybody to ask questions. And Emily, can you tell about Immigration Girl blog? This is that you publish every immigration news that is related to the employment-based immigration.
Yeah, so if you want updates delivered straight to your email box, anytime anything new is happening specifically for employment-based immigration, really the practical things, not the theoretical things, you can go to immigrationgirl.com and subscribe, enter your email address, and every time I post a new article with an update, you'll receive that in your inbox. And also, if you would like more information about your specific case, want an answer to your specific question based on your circumstances, you can set up a consultation with any of our attorneys by going to rnlawgroup.com and clicking